Near and dear to my heart is the next panel because it's all of my colleagues in the Network for Public Health. Well, not all of them, some of them. Those that were on my good side or bad side, you figure out who gets to come and talk today. Matt, Gabby, Blair, Brooke, Hans and Tessa. I know, this is amazing. What Matt just pointed out is everyone who is about to be on this panel has been a student of mine, which is pretty awesome.
I was like 19.
I was 12 when I started teaching. I'm the Doogie Howser of law professors, and half of you don't even know who Doogie Howser is, so thanks. So I am going to let you guys introduce yourselves since there's just so many of you. Hans, yeah, pull over a chair. But we wanted to get, this is literally like a tasting, right? These are small plates. Rather than have each of these guys do a full-on presentation, we wanted to have guests to come talk with you, but we still wanted to do this quick hit panel where you see kind of the breadth of the work that we're doing across the Legal Resource Center and the Network for Public Health Law. This is literally, an inch of our yard of work, but I wanted you to see that, and hopefully this entire day, particularly this panel, is going to inspire you to make technical assistance requests, any questions that you have on legal issues in your public health practice. So on that note, I'll turn it over to Matt. Wants to go last. That's all. Look, I am out of this little fight, so I think I'm going to make Brooke go first. There you go, Brooke. I think the boss has problems.
I'm Brooke's IT support, that's why I'm up here, and Brooke is in trouble with me as her IT support. I'm just going to let you do what you need to do.
Stand by because I don't do well with this. What do? You say? There we go. All right, good afternoon, everyone. Thank you for making it to I guess this is our final hour of the day. For those of you who I have not yet spoken to or had the pleasure of meeting, my name is Brooke Torton. I am the Deputy Director for the Legal Resource Center. That is essentially the sister organization for the network. We're both housed here at the law school, both under Kathy Hoke's leadership. And I am really here today just to talk to you a little bit about what I do personally, just to give some key information about something that actually I've heard about quite a bit in the news lately. Many of you have as well, and especially we're all public health minded. You've probably heard about some of this professionally as well. So I just want to give some key updates as it relates to the electronic nicotine delivery systems and just federal regulations. So because I've got I think 7 minutes, maybe something like that, a very short period of time, this is just going to be high level. I don't want to get into too much detail, though this is something that we could really spend hours talking about. And just want to also say we're funded by the Maryland Department of Health. We don't engage in any kind of advocacy, litigation. We really provide technical information and technical support. All right. So back in 2009, the Tobacco Control Act was passed by Congress, and it gave the FDA authority over tobacco products, and it required that they adopt certain requirements for all tobacco products under its authority. So it gave immediate authority to products like cigarettes, cigarette tobacco, roll your own tobacco, and smokeless tobacco. And very importantly, it also gave the FDA authority to assert additional authority over other products to deem additional products as subject to their regulation. And so that is why ultimately in 2016 we have what we refer to as the Deeming Rule, because this extended the FDA's authority to additional tobacco products. And this is really what that included is electronic cigarettes and some of these other products here, cigars, hookah, but for our purposes, because there has been what's being referred to as an epidemic with youth and electronic cigarette use, that's really going to be the focus of what I talk about here today. So when I say, you'll see I use these terms interchangeably. I'm not very good about this, but essentially when I say ENDS, I'm talking about it's electronic nicotine delivery systems, but sometimes, that's what we call it here in Maryland, though that might change this session. Stand by for that. We also refer to this as electronic cigarettes or ESDs, electronic smoking devices. So I'm really talking about generally the same thing. Okay, so what does electronic cigarette or ENDS, what does this include? This is a battery-operated product. It heats nicotine, flavor, and other chemicals into an aerosol that the user would then inhale. And there is quite a range of what these products look like, how they're used. I've listed here for your purposes just a little bit about what these look like. They can be big, they're small, they can be small. And I just want to also highlight, there's a lot of misinformation out there about whether or not these can help adults quit using traditional tobacco products. There's some evidence to suggest that this may be the case. This isn't being said conclusively yet, but I just want to highlight that these are not products that are safe for youth use. And there is, like I said, what's being called an epidemic with youth use, and part of the reason for that is some of this mixed messaging that they're getting. So these products contain diacetyl, which is linked to serious lung disease, some other heavy metals. When users inhale, they can get some of these heavy metals like nickel in their lungs, some other poisons. Specifically for youth, these products have nicotine, and we know that that can harm a developing brain and impact substance abuse and use throughout their entire lives. Okay, so Juul. Juul is really a brand, but this is a really specific type of electronic cigarette resembling a USB. The Juul product has a lot to do with what's happened with youth appeal and youth use over the past about 2 years. So the liquids in these Juul pods, by the way, this looks like a little USB. So this is another part of the huge issue, is that students are bringing these to school, which actually I'm told that's fairly common, that students actually bring USBs to school for projects. I'm somewhat removed from high school, but when I was in high school, nobody was bringing USBs to school, so took me a few minutes to kind of get caught up understanding what's happening in schools today, but nonetheless, they're bringing these to schools. Sometimes students do bring USBs, so there's some confusion over what this product is. It looks like a USB, but nonetheless, there's a pod that's contained in there. It contains these nicotine salts, and that's absorbed into the body at a rate that's almost the same as combustible cigarettes. And so I just want to say a word about Juul. They have more than twice the amount of nicotine as other brands of cigarettes, and they presently have a 72% market share on electronic cigarettes. So they are the name. And so for that reason, a lot of times using electronic cigarettes, it's commonly referred to as juuling. It's become a verb, even though it's a noun. We also hear vaping too. That's another word that's used to describe the use of these products. All right, so when the rule was published, it was released in May of 2016, and then it was ultimately became effective August 8th, 2016. So I'm not going to get into any significant detail about what this rule did. We talked about the products that it would cover, but for our purposes, I just want to talk about one brief provision, and that's that last one you see in red, that this rule would subject all of these new products to pre-market review. And this wasn't going to be an automatic provision. What this said essentially was, if your product was not being marketed by February 15th, 2007, then you need to go through this pre-market review process. And that means there are a few different types of applications, but essentially, in order to continue selling, you have to go through this process. And there was this date. An application essentially didn't have to be submitted until it was either February 2021 or 2022, depending on the kind of application. So regardless, even though these products were already on the market, they technically had to submit a request to continue selling them. And so really, none of these products, these electronic cigarettes, were on the market before that February 2007 date. So any kind of manufacturer of these electronic cigarettes would have to ultimately go through this process. So in the interim, these products could stay on the market, and they did, and we still see them, of course, now. So I just want to skip ahead a little bit to 2017. We heard from the FDA commissioner, and this was something that I believe they were contemplating for some time. But a plan was announced to develop certain regulations that would lower the nicotine levels in cigarettes to potentially non-addictive levels. And so the idea was that by reducing the addictiveness of cigarettes, users might be more likely to quit, and then youth, of course, less likely to ever begin smoking. And so the joint announcement with this was that the Deeming Rule, the regulations, many of those are going to be put on hold somewhat indefinitely until we work out this new framework. So then skipping ahead about 13, 14 months after that, at this time in that past year and a half, there were some very troubling trends emerging with youth use and electronic cigarettes. And so the FDA, they announced this series of enforcement actions related to the sale and marketing of electronic cigarettes. This resulted in about 1,300 warning letters. There were some civil money penalty complaints. There were some no tobacco sale orders, and so they were making significant steps because they began receiving data that the increase was very troubling and the youth use was becoming what they were calling an epidemic. And so there were some very specific quotes. Commissioner Gottlieb used language to let the retailers, manufacturers know that he was not kidding. He was very serious about this. Look out for additional steps, and you need to, retailers, manufacturers, you need to be working with us on letting us understand why this is happening, what's happening with youth, and how can we work to curb this. So then skipping ahead to, it's been about 4 or 5 months. I'm sifting through these monthly, sometimes weekly updates from the FDA to get a sense of what they're going to do next because the numbers are troubling, and I'm going to talk about what they are in just a second. So moving forward to, I believe it was October, yes, of 2018, the FDA sent letters to electronic cigarette companies, and this time they were asking about flavored electronic cigarettes, trying to gather some more information about that. And Commissioner Gottlieb refers to flavors as being the principal drivers in youth appeal. There was also a meeting that took place around this time. This was between the commissioner and some of the big-name electronic cigarette companies, essentially just trying to ask, kind of having like a kumbaya get-together to determine what was happening. And essentially what was published from that meeting were that commissioner says, these companies acknowledge, yes, flavors have a role in this. Some of the companies even referenced increasing the age to 21 as a way to help curb youth appeal. And they do acknowledge that there are health concerns with youth using these products. All right, so moving forward to November 2018, this is when the CDC, they formally released their findings from the National Youth Tobacco Survey. And so there were, in 2018, it was up by 1.5 million students nationwide, that 3.6 million middle and high school students were current users of electronic cigarettes, current meaning past 30-day use. There was a 78% increase in high school students' use and a 48% increase in middle school students' youth. And so obviously, these numbers were very concerning. And there were some potential policy changes that the commissioner stated they were going to consider looking into, and I've sort of highlighted here some of the concerns. So one, flavors, all across the board research has showed this is something that attracts the youth to these products. So that was something that the commissioner or the FDA was going to consider very carefully examining. How they can access these, whether online or in person, they were going to consider making some changes there. And then flavored cigars. That's not an electronic cigarette. A cigar is a cigar, which is a little different, but there actually is a rule underway that's going through the formal rulemaking process that's dealing with flavored cigars. And then there's also a policy on banning menthol in combustible tobacco products. That was sort of an exception when the Tobacco Control Act was released, but it's something they are reconsidering for a similar reason, the flavors being something that attracts our youth to these products. And then, of course, ends products that are being marketed toward children, that's something they're going to take a careful look at as well. So these are this gave us some clues, some hints as to what we can expect to see in the coming months. And so then fast forwarding to, this was like maybe a week ago, this might have been last week, we're tracking this all the time. There were some additional statements about the National Youth Tobacco Survey that I just referenced was released. Some additional numbers and analysis there. Just that this trend had been tracked by other means as well. This wasn't an anomaly. This has been seen in other studies, recent studies. And that among current tobacco users, about 2 in 5 high school students, and then 1 in 3 middle school students had used 2 or more tobacco products in 2018. That the most commonly used tobacco product was a combination of electronic cigarettes and conventional cigarettes among both middle and high school students. And then again, we see these planned action steps. These mostly highlight what I just talked about a moment ago. They're going to continue doing the enforcement that I mentioned, that the announcement they made in September. They're continuing with that project, that program. They're also going to be looking into special nicotine cessation for youth programs. Because this has become such an epidemic, they're trying to find a way to help reverse that, so that is going to be a focus. There's something called the Real Cost Campaign, and so I don't have time to pull this up and play this for you, but I would suggest you check that out. You might have already seen some of this. It's to try to assist in clarifying and clearing up some of the mixed messaging that our youth are getting on these products. There's also an announcement that they're planning to meet with the state attorneys general, and so we'll be tracking very carefully what comes out as a result of that meeting. And so there are probably some questions there, but I understand I'll provide my email address here, happy to reach out, or happy to answer any questions if you reach out. And yeah, thank you so much.
I don't even know where the keyboard is. Is this today? This is today. Okay, hi everybody. My name is Blair Inniss, and I am the staff attorney with the Legal Resource Center, so I thought it would make sense for me to go next since Brooke and I are the two Legal Resource Center people here. So Brooke did a really great overview of kind of the general landscape, especially as it relates to youth and vaping. You saw a slide on there that Juul has 72% of the vaping market, and so we pay a lot of attention specifically to Juul for that reason. So one of the things that I do here for the Legal Resource Center is track any lawsuits that are going on related or against Juul. And so right now there are 6 that I'm tracking. I absolutely expect there to be more. This last one just came out like last month, so a lot going on with the lawsuits. But the cool thing is, even though there are a good number that we're following, they actually really have 2 general themes that I wanted to talk about today. So the first, and I should say also that all of the claims that are arising here and all of these lawsuits relate to the time before the FDA was regulating anything. And so now there's a lot happening to help try to stop and curb this, especially youth vaping epidemic, but for a number of years, truly, I call it the Wild West of vaping, because truly there was no regulation, and companies such as Juul and Pax Labs, who created Juul, were taking advantage of that. I come from a marketing background before law school, so the marketer in me is actually kind of impressed, I'm not going to lie, with the marketing campaign that Juul used to really attract the youth to their product, because it clearly worked really well. But the public health person in me and like the moral person in me is very unhappy with the way that everything went down. But so the 2 kind of broad areas where we see in these lawsuits, the first one relates to labeling and false advertising, and there are kind of 3 big themes that I want to talk about there. So the first one, the certain chemicals which deliver an exceptional potent dose of nicotine compared to traditional cigarettes. So that has to do with the use of nicotine salts. You might have heard that in the Juul pods. I don't know science, so it has something to do with the pharmacokinetics of that, and it took me a long time to even learn that word, so can't even say more than that, but generally speaking, it's the fact that Juul has not told anybody about the use of nicotine salts, and so people are not realizing that there is so much nicotine in the Juul pods compared to a combustible cigarette. That also goes to, you might have heard people saying how addictive these cigarettes, or these pods and Juuls are. It goes to the use of the nicotine salts. The second bullet, talking about the packaging, can you see? Nope, you can't. So on the packages, it actually says 5% strength, and so really the packaging, the allegation is that the packaging is misleading as to the dosage of nicotine, because in fact, or not in fact, but what people are saying is that it's actually more than 5% strength. It's more like 6.2% as far as the dosage of nicotine that you're getting from a pod. And then the last argument having to do with labeling and false advertising is really that the Juul claims that each pod is equivalent to nicotine in a 20 cigarette pack, and the allegation is that it's more than that. So I will say, despite having all of these lawsuits, we're seeing a lot of like administrative motions right now, so none of the real facts or merits of the cases have been decided yet. So we're going to keep watching for that. I expect it to be quite a while, honestly, before we start to see anything of true substance, though. The other big allegation that we're seeing in all these cases has to do with Juul's marketing practices. So all of these pictures are things that you're seeing from social media and print advertising. And again, this was pre-FDA regulation. But so the marketing practices, really the argument is that the marketing practices were created to attract and addict young people, youth, to their product, right? A whole new generation of users. And so you can see some of the work that they were doing there. This bottom left, oh, you might not be able to see it very well. This is their print campaign, and it showed up in a bunch of different magazines. One of the popular ones, or at least one of the ones that I've heard of that it showed up in, was Vice magazine. And for those of you who were at my table during lunch, then we were also talking about Vice also has a cooking show on cooking with cannabis, just to give you an idea of the age of the people that they are advertising to. This is not a magazine that is specifically advertising to the mature adult crowd who are allegedly the target of the Juul products. And so you see these young people, you see bright colors. You might not see bright colors there, but here it looks good. And so, I mean, it's just a really exciting advertising campaign. Also, I will say that some of these pictures did show up also on billboards in Times Square. So it wasn't a low-budget advertising campaign either. The middle picture, this comes from Twitter. So when Juul launched, they did they had like launch parties across the country, and they did a really great job of hyping it up through social media. And so this is one of the launch party Twitter pictures. So they were actually encouraging people who were at these launch parties to take these pictures and then use specific hashtags. So their use of hashtags, you'll see it in all of their, well, now you won't see it. They actually did take down some of their social media work, but back before they did, their use of hashtags was really big, and they had some very specific ones they were using. So you'll see both in this Twitter picture, and then next to it on the right is the advertising billboards and campaign for preparing people to go to the launch parties, and you'll see more of the hashtag use there. So there's actually, Juul Vapor is actually boxed in red on that far right picture, and they were even putting in the hashtags when other people weren't. Is everyone familiar with hashtags? I'm like using these terms like everybody knows. We all know, right? No? Hashtags are a way to search out certain topics on various social media sites. And so, for instance, you know, I have someone who, something really innocuous. She was looking for bunk beds, and for some reason she like used the hashtag bunk beds on Instagram and found it there. Like you can use them for anything. And so searching for Juul and Juul Vapor, they are creating this community and this hype around the product. And so this was some of the ways that people are saying, yeah, no, look, this specifically speaks to younger people. This is something that the younger people are using. This is not something that, like, you know, the actual market, the people you're supposed to be marketing to, are using as commonly and as frequently as the younger people. So these are some of the things that they saw, and these are some of the things that we're seeing in the court cases as well. Again, this hasn't gone anywhere, although we will say now that we have the FDA doing some stuff, like what Brooke said, a lot of good things have come out of it, but a couple of good things specifically related to this. First of all, as of June 2018, Juul is no longer featuring like models like that on Instagram, Twitter, or Facebook. So they are instead featuring former smokers who used Juul to quit smoking, because of course they are marketing this as a smoking cessation product. And then also as of November 2018, this is a big one, Brooke talked about the flavors being very interesting to the youth and helping to get them started on Juul. So as of November 2018, they've stopped accepting retail orders for their mango, fruit, cream, and cucumber pods. So there is tobacco and menthol flavored pods that are still available at the retail level, but for any of the flavors, that is now only available on their website that does have heightened age verification requirements. So it's a start. So we're going to continue to follow this, but like I said, it's definitely going to be a bit of time before we start to see any substance coming out of these lawsuits. That's all. Thank you.
Right, so I don't have any fancy slides, so I don't need any technical assistance. It's just going to be me. So good afternoon, everybody. Thank you all for being here and for sticking it out till the end of the day. My name is Gabrielle Shirley. I'm a staff attorney with the network. Since I started back in the fall, I've been working with the network on a variety of different public health topics and updating a lot of our existing products. And one of those I want to talk to you about today is the status of protections for victims of domestic violence in same-sex relationships. So one of the things we want to know was where the country stands right now with respect to protecting this segment of the population and to what extent protections may have been impacted by the legalization of same-sex marriage. So what we did was we undertook a 50-state survey to determine what laws exist, whether they extend protections that include same-sex couples, and to what extent these laws may have changed since the 2015 Supreme Court decision of Obergefell, I always screw this name up, Obergefell, which legalized same-sex marriage. And the last time the network had actually looked at this issue and these various state statutes was just prior to the legalization of same-sex marriage. So I thought it would be interesting to go back and look and sort of see the status of where we are today. So just as some initial background, every state has some form of civil domestic violence statute. And these statutes are designed to allow victims to petition the courts directly for protection, as opposed to criminal statutes that need to be enforced by the state. Domestic violence is typically defined as abuse or violence between family or household members, and family or household members are legal terms of art. They're defined differently in different states, but what they have in common is that these are categories used to protect specific subcategories of individuals. So for example, common categories include current or former spouses, current or former cohabitants, or individuals currently or formerly dating in romantic or otherwise intimate relationships. So every state uses a different formulation, but that's the basic, those are the basic categories that they cover. If you don't fall into a protected category, you may still be eligible to protection, but to a much lesser degree. So for example, Maryland is a perfect example of how this plays out. Maryland has both protective orders and peace orders. Protective orders come with a laundry list of potential remedies, whereas peace orders are much more limited in scope. Protective orders allow judges broad discretion to fashion orders that fit a victim's particular circumstances. That goes far beyond a protective order. So it's significant to be able to fall under the protected categories in these civil domestic violence statutes because it elevates the level of protection that a particular individual can get. So prior to 2015, access to protections for domestic violence victims in same-sex relationships was questionable because married same-sex couples didn't automatically fit into a protected category in states that either prohibited same-sex marriage or found it to be invalid. And then fast forward to after 2015, where the Supreme Court extended the right to marry to same-sex couples. With this decision, victims of domestic violence and same-sex marriages were now automatically covered under state civil domestic violence statutes, as typically under the category of family members. But what this doesn't tell us is what about domestic violence victims in same-sex relationships in general? So we wanted to look at that question and specifically how, if at all, progress on the issue of same-sex marriage may be instructive. All states, I'm happy to report with the exception of North Carolina, have gender-neutral civil domestic violence statutes, this is good because it increases the likelihood of the extension of protections to victims of domestic violence in same-sex relationships. But is gender-neutral language really enough? Is that enough to afford people the necessary protections? And how are states going to enforce and interpret those laws? And one of the ways we thought we could figure that out is by looking at how states have reacted to the same-sex marriage legalization decision. Okay, so as we all know, Supreme Court strikes down a law. We know that it becomes unconstitutional. It's no longer valid. But what happens to it? Okay, so what we were able to determine by looking at every state's marriage laws was to see what, if any, steps they took after that decision to remedy their offending statutes. And it was interesting. The most common approach is to take absolutely no action at all. Okay? You can read into that or you cannot read into that. It could be that states just haven't gotten around to it yet. They think that the Supreme Court decision was enough, or you could read into it that there's still some states with negative attitudes towards same-sex marriage and same-sex relationships, and taking no action is actually expressing that view. Some states have attempted to repeal the offending statutes. Some have successfully replaced the offending statutes with gender-neutral language. But some have even gone a step further to codify laws that explicitly protect the rights of same-sex couples to marry. But the overwhelming majority have taken no action at all. So the approaches are telling because they can have a trickle-down effect when it comes to enforcement of domestic violence protections for same-sex couples. It's reasonable to think that jurisdictions taking active steps to replace any laws adversely affecting the rights of same-sex couples to marry would be receptive to extending other rights and protections to non-married couples. But that's a word of caution as well, because in jurisdictions that are either indifferent or have been hostile to same-sex marriage, the lack of explicit protections for same-sex couples renders same-sex domestic violence victims vulnerable to an unreceptive and unsympathetic legal system. And we're actually asking victims of domestic violence to take a leap of faith here and trust that the same institutions are going to protect them that have also historically been prejudiced against them. So nearly every state, as I said, uses some sort of gender-neutral language in lieu of a blatant protection for same-sex couples. On the one hand, it leaves the door open to the argument that victims in same-sex relationships are covered, so that's positive. And where case law does exist, where these statutes have been addressed, courts typically conclude that statutes are to be broadly and liberally construed in order to provide maximum protections for victims of domestic violence. So again, this is positive, because this means that at least the door is clearly open. But what we need to look at is the interplay between the law and the realities faced by the community that is going to be attempting to access these laws. And it's interesting to do that in the context of just the general reasons why victims don't come forward to begin with. And there's a lot of research on this topic, but just to sort of give you a list, so that before you even are talking about stepping foot into a courthouse and asking for protections, these are some of the barriers that victims of domestic violence and same-sex couples are grappling with. Many victims fear stigmatization and choose to suffer in silence rather than face additional and further oppression. There's gender-related stereotypes that have to do with same-sex domestic violence. For example, that only women are victims of domestic violence, women don't victimize other women, that men don't victimize, they're mutually aggressive. You know, these are all some of the stereotypes that just exist out there that tend to inhibit people from coming forward. There's fears of outing oneself when seeking help, a lack of awareness of LGBTQ-friendly organizations that can provide help and assistance, a lack of understanding from staff and service providers of other victims engaged and of other victims engaged in these organizations. And in general, there's a low level of confidence in the sensitivity and effectiveness of law enforcement officials and the courts towards LGBTQ people in general. So before even stepping foot in the door, these are all of the things that a lot of individuals in these circumstances are grappling with. And then you compound that by the fact that we have fairly broad laws that may provide protection, but it's not explicit. And the lack of explicit protections can lead people to feel inhibited about even bothering to come forward, particularly in states that were found to be hostile towards same-sex marriage to begin with, even despite a Supreme Court's decision legalizing it. Fortunately, in the research we conducted, North Carolina and South Carolina were really the only outliers that have either a statute or portions of their statute that actually exclude same-sex victims from protection. The North Carolina law is actually being challenged right now by the ACLU, so update to come on that one. And the South Carolina law, the courts, it was interesting, the courts actually struck down the portion of the law that was unconstitutional, but in doing so, rendered no protections for either same-sex or opposite-sex couples that were in intimate relationships, which is obviously a mess and not what the legislature intended. So South Carolina has been taking some actions locally in the courts to try to send the message that that was not the intent. And so these laws are intended to be enforced, but it's still something in flux because it hasn't actually been addressed by the legislature. So the takeaway is really that where there's ambiguity, there's always uncertainty. And overall, the conclusion would be that, yes, there's a lot of gender-neutral laws, and that the ability to protect same-sex victims, it's there. The arguments are there to be made. But if it isn't clear, there's always going to be the risk that intended victims are not going to be covered. And the additional questions that flow from that are also, will victims come forward without specific protections? If they do, are the statutes broad enough to leave discretion completely in the hands of unsympathetic justices, where the laws could be applicable, but because of societal attitudes or because of the judges' attitudes, frankly, are they going to extend those protections or find ways not to extend the protections? And also, even if granted protective orders, how will law enforcement go about enforcing those orders on the ground? So a shameless plug here. We are planning to host a webinar in late March to address some of these issues and really how the laws as drafted, how people in this area of domestic violence and providing services have actually seen these laws play out in reality. So please join us for that. Thank you very much.
Okay. Hi, everyone. My name is Tessa Devereaux. I am a 3L here at the law school. Last spring, I was in the public health law clinic with Kathy, and my partner for clinic was Hans, and we also worked with Brooke. So today, I am here to discuss the topic of medical cannabis advertising. This is a particularly relevant topic in light of currently proposed legislation that is waiting to be heard in front of the Maryland General Assembly. More on that later. And this is also highly relevant in light of new regulations that were proposed in December of 2018 by the Maryland Medical Cannabis Commission that would also place certain restrictions on medical cannabis advertising. So as some background to this issue, as I said, my classmate Hans and I were in Kathy's clinic, and we were assigned to do work on medical cannabis advertising. As of last year, 30 states and the District of Columbia, and I believe it's 33 now, had legalized cannabis for either medical or recreational purposes. And that includes Maryland. Out of these 30 states and DC, as of last year, only 19 states and DC had laws that restricted advertisements of medical cannabis. 2 states prohibited advertising altogether, and then there were 9 states that had no restrictions on advertising. As of the 2018 legislative session, Maryland was one of these states. In the 2018 legislative session, a bill failed that would have placed certain restrictions on medical cannabis advertising in the state of Maryland. So following the 2018 legislative session when this bill failed, the Maryland Medical Cannabis Commission set out to promulgate regulations that would place restrictions on medical cannabis advertising. So alongside the commission's efforts, Hans and I conducted a 50-state survey that looked at what other states have done in their approaches to regulating cannabis advertising, and also the types of restrictions that were in place. Based on the approaches that other states have taken, in December of last year, the commission passed their own regulations that placed certain restrictions on medical cannabis advertising, which will now wait for legislative review in the 2019 session. And as I mentioned before, there is current legislation, Senate Bill 859, which awaits to be heard in front of the Maryland General Assembly later this month, and that would also propose certain restrictions on advertising. So now I'm going to get into the results of what Hans and I found in our 50-state survey, and how Maryland's approach in regulating advertisements would compare to measures that have been taken by other states. In conducting our 50-state survey, Hans and I found that advertising restrictions generally fit into 4 broad categories. These include medium restrictions, content restrictions, physical restrictions, and finally restrictions on bias. So in looking at medium restrictions, they govern how advertisements can be disseminated to the general public. So the Maryland Medical Cannabis Commission has passed a number of medium restrictions. One is that they had placed a ban on advertisements over the radio, television, and billboards. So all of the billboards that you see coming into the city would no longer. And as of last year, interestingly, only one other state, which is Ohio, had outright banned all radio or television advertisements. And then seven other states have varying other restrictions on television and radio advertising. The commission has proposed to ban advertisements on print publications unless at least 85% of the audience is reasonably expected to be 18 years of age or older. And 7 other states have taken similar measures in restricting advertisements in print form. Relating to content restrictions, the commission has also proposed to ban advertisements on any website, mobile app, social media, or other electronic communication that doesn't have some sort of a neutral age screening mechanism to ensure that people that are seeing these advertisements are over the age of 18. So next, in looking at content restrictions, so that's somewhat self-explanatory, but pretty much there are restrictions on the content and messages of the advertisements. So the commission's regulations, as well as the proposed legislative bill, would prohibit advertisements that make statements that are false or misleading in any way. 13 states and DC have also restricted the validity of statements within advertisements and said you cannot have statements that are false or misleading. The commission would require that advertisements contain a statement that the product is to be used only for qualifying patients, so patients that have gone to their physician and obtained a registry card. 5 other states and DC have taken similar measures by prohibiting advertisements from encouraging or promoting recreational use of medical cannabis. The commission requires a warning that there are certain health risks associated with consumption of the medical cannabis or product, and 8 other states have also required product warning and advertisements, including health risks associated with consumption and warnings of possible mental or impairment effects. And other states have taken measures that the commission regulations and proposed legislation have not included. So for instance, 7 states prohibit advertisements from offering gifts, prizes, or other inducements relating to cannabis sales, which was not included in the regulations proposed by the commission or within the currently the legislative bill that's waiting to be heard. 6 states prohibit the use of curative or therapeutic claims in advertising. 5 states prohibit statements on the safety and efficacy of medical cannabis. And finally, 14 states restrict advertisements that target children or have any content associated with children. So for instance, cartoons or anything that would capture the attention of a child. So the third broad category of restrictions that Hans and I found throughout state statutes and regulations are restrictions on bias. So states have taken 2 types of regulation, or 2 types of approaches in relation to regulations on bias. 3 states prohibit advertisements that contain bias toward or against specific entities or providers, and then other states, 5 states prohibit advertisements that contain statements showing bias toward or against specific medical cannabis products or brands. And then the 4th broad category of restrictions that we found are physical restrictions. So 12 states and DC have regulations on the physical space of advertisements in some way. Physical restrictions we found have varied, but states have implemented regulations including signs, or prohibiting signs within close proximity to schools, signs on public property or transportation, signs visible to the general public, as well as restricting the size and other physical features of the advertisement. So in Maryland, the commission's regulations would ban advertisements on public property, as well as handbills, leaflets, or flyers distributed on public or private property without consent of the owner. So that was just a taste of the approaches that other states have taken in their statutes and regulations on advertisements and how they compare to the regulations that the commission has proposed and what to expect with the legislative bill that is still waiting to be heard this coming year. Thank you.
Good afternoon, everyone. My name is Hans Wei, and I am also a 3L like Tessa. She introduced for me. We were both in Kathy's clinic last year, and this year we've both been acting as research assistants for Kathy and have been working on some special projects. The one we've been working on for this semester is we were approached by the Midshore counties to put together an opiate treatment substance abuse resource kit for private individuals. Obviously, I think many of us are in the know and we understand what kind of social services are out there for individuals. A lot of people who aren't in the know have no idea the totality of services out there. And so the Mid-County Public Health Department's idea was to put together something like a bench book for anyone who wants to get treatment, who's interested in treatment, or primarily anyone who's come in contact with the law. And this is important because currently there's only, I guess, 3 main ways for people to come in contact with public services if they have a substance abuse issue. The first is if they can self-refer themselves to any of the treatment facilities, or if they've already engaged in services either through Medicaid or Medicare or SSDI, and they have a therapist, they can be referred by their mental health professional or any medical professional that they are currently seeing. But that doesn't help anyone who is looking for information regarding it. Perhaps they aren't as willing to come forward due to the stigmatization, or they just have a general distrust of the government and feel that any kind of asking for help could put them in potential dangers with the law. And that is pretty significant, as I'll address in a second, because the other 2 avenues really are not ideal for anyone who's suffering from substance abuse. So a large part of our resource kit will be links and descriptions to like SAMHSA, which is the Substance Abuse Mental Health Security Agency, and they have a website that you can put in your zip code and they will show you a list of treatment facilities in your area that you can check in for inpatient, intensive outpatient, or outpatient therapy on your own. There's the Maryland Behavioral Health Administration website, which does a lot of this. It provides a lot more for Maryland specific. There's 211maryland.org, and then there's also listings for sober homes, county crisis response teams, and the core service agency resources on there as well for people who perhaps don't want to go through an intermediary to be able to engage in those services. So the next major one is when an individual enters the justice system, the criminal justice system. If we begin with the assumption that everyone is innocent until guilty, then there's actually very little opportunity for them to receive treatment during either pre-trial or during the pendency of a trial. There's one main mechanism in Maryland, which is Maryland General Health Article 8-505 through 507. 505 allows a judge to refer the defendant or the suspect to mental health assessment and determine whether they qualify for mental health treatment, whether they actually have a substance abuse issue. And then 8507 is the actual statute that the judge can refer them to a facility. Compliance with these programs typically really only happens at the end of trial, which means that usually they have been found guilty of some kind of underlying crime, regardless of whether they want to claim that it was a result or compounded by their substance abuse issues. These situations are always judged case by case. There is no schema for a normal defendant going through the normal court system. And typically judges depend on counsel, social workers, or other interested individuals to recommend some kind of a plan. That means they do not have any kind of formalized list referring defendants, any kind of formalized list referring defendants to individuals or to treatment facilities. So it's really kind of messy when you think about it, because it's a very important time in a person's life when they're going through a criminal trial. And any result, aside from a not guilty verdict, they're going to have to live with that for a very long time. And especially if they are incarcerated, once they start serving a sentence, treatment matters even more, because there's a high addiction rate, there's high exposure to drugs in prison itself. And then finally, Maryland luckily has a drug court. There's a federal drug court as well, and some of the states have it, but not all states have a drug court. But what we've seen is that, at least in Maryland, it's reduced recidivism rates by up to 60%. In Florida, they have a very robust system, and that's actually reduced recidivism by up to 70% of not only the underlying crime, but also treatment. In the normal world, the non-criminal justice world, I believe, not necessarily recent data, but at least of 2016, 2017, from the SAMHSA website, they've shown that I believe it's about 270,000 individuals who've checked into a treatment facility, around 49 to 51% actually complete treatment. The rest typically drop out or are terminated for some other reason from the facilities. And that's major. I mean, when you compare it to a 60 to 70% non-recidivism rate. So Maryland's drug court, luckily, is pretty robust. It's a 4-phase system. The first phase involves a clinical assessment by the drug court. They are determined for eligibility, and they must plea into the court. Much like the mental health court, that means whatever crime they're accused of, they have to plead guilty before they're even qualified for drug court. In phase 2, they will go under usually an inpatient treatment, and then they will be supervised by the Department of Parole and Probation. They will have to submit urine analysis, meet with their probation agent multiple times a month. And this basically assumes that they're going through the treatment plan that's been decided by the members of their, basically each person has a drug treatment case. Then phase 3 is the beginnings of the outpatient treatment. Generally, some defendants are moved to phase 3 directly because their substance abuse isn't as intensive or as severe as others. And this is, again, it's supervised probation. They still have to submit urine analysis, and participants have to agree to home visits. And then finally, phase 4, they've completed all formal aspects of treatment, but they are still under supervised probation for whatever length of period of time that the court deems necessary. They also have to engage in court conferences for at least on a monthly basis, and depending on how well they completed treatment, the judge is obviously empowered to change it to unsupervised probation or any other conditions. So the drug treatment court team that's assigned to each defendant composes of a judge, a coordinator, if they have defense counsel, or if not, then someone from the Office of the Public Defender, the state's attorney, the continuing care coordinator, a social worker, a case manager, the drug court supervisors and supervising agents, criminal assignment, and usually a therapist. So, I mean, you consider that's around 10 to 12 people for each defendant. But again, that requires them to plea into it. It requires them to get help from this kind of qualitative care. You have to admit that you committed a crime and carry that with you for an extremely long time. The program itself, average length is about 2 years, and it'll obviously depend on each participant's ability to complete the programs. And that in itself is not an insignificant amount of time to be under some kind of supervised probation. So I think the crux of the resource kit is to give people an avenue and an idea that you can seek treatment before anything major happens. And that even if something major happens, you can still get treatment, and that these social services are here for them. It's not here to stigmatize them, it's not here to punish them, and that reaching out really at the beginning is much better than trying to reach out at the end. So that'll be something that we'll make available to the mid-shore counties and anyone else that wants to have it, maybe use it, or publish it on their website. So thank you.
All right, I've got 4 minutes. I have never talked for 4 minutes in my life. But hopefully I can entertain you for at least 4 of the minutes that I'm talking. My name is Matt Swinburne. I am the Associate Director here at the Network for Public Health Law's Eastern Region. And most of my work that I do normally is on food policy, whether it's food security, so making sure people have enough healthy food to eat, or food safety, making sure that our food supply will not cause illness. But I also do a grab bag of other things, from vaccine policy to injury prevention. And for a long time, we had this guy, Will Tilburg, who was really good at cannabis policy, but unfortunately he was so good, the Cannabis Commission stole him from us. And in the power vacuum that this created, gave me an opportunity to learn some new things. And so really I've started to do some research into the area of cannabis regulation. Probably summer of last year, we started getting some questions throughout Maryland, first looking at how does a medical cannabis program deal with pediatric patients versus adult patients? And so this was kind of my gateway into working in this area. But this legislative session has brought a cascade of new questions our way. And one of the questions that we're starting to see is really, how are cannabis edibles regulated? And here in Maryland, this is a pressing question right now because we have a bill that would legalize this product within our medical cannabis system. And the reason I think that a lot of people have a bunch of questions is because cannabis regulation is changing a lot, and it's changing quickly. I guess the theme of this, and I was thinking like, oh, how do I tap into the theme? What was old is new, or new is old? How many states had legal marijuana in 1935? All of them, all of them. It wasn't until 1937 that we criminalized cannabis in the United States through a federal tax act. And kind of the cannabis regulation we see at the federal level really today is out of the 1970s Controlled Substances Act. But there's been a movement at the state level to go, I guess, back to the 1930s model of legalizing this in different ways. So 20 years ago, when Shakespeare in Love had won Best Picture, only 4 states had legalized medical cannabis. None had adult use, which people often refer to as recreational programs. 10 years ago, Slumdog Millionaire, we had 13 states with legalized medical programs and no adult use programs. So fast forward, we don't know who's going to win the Oscar just yet for 2019, but the landscape has changed. We've got 10 states and DC who have adult use programs. We have 33 states that have comprehensive medical. So that means allowing essentially products that have higher THC levels, because you have some states that have what we refer to as limited medical programs that essentially allow for CBD-based products and not the THC, with THC being the psychoactive component and CBD being the analgesic component. So we've got this rapidly changing landscape, and I like the term of the Wild West for regulation of Juul and ENDS. I think that really applies to cannabis as well. We, as public health practitioners, are learning. It's great not being the first person to do something. we can learn from the mistakes of Washington and Colorado and California and Oregon. And edibles present a unique challenge from a public health perspective. But before we kind of get into some of those issues, how big of an issue kind of in terms of scope are edibles? Well, 2017, they estimated that the value in sales from legal cannabis is about $8.5 billion. And 12% of those sales nationally were from edible products. Now, it varies from state to state. So you have a state like Colorado or Nevada where it's close to 50% of their cannabis programs, the income comes from the sale of edibles, where other states like Washington, it's closer to around 9 or 10% of the revenue in their cannabis programs comes from edible products. Part of that is the range of products that they make available within those programs, and also kind of, I think, the idea of cannabis tourism, which is a thing, apparently, plays into what products people approach in these states. But edibles are a market that is growing, just like the legal cannabis industry itself is growing. So in the next 5 years, estimates that edible sales will be around $3.3 billion in the United States. So I think there's some common sense challenges that these present. These aren't your grandma's brownies. That's actually from the state of Alaska and their health department, kind of, in a humorous way, addressing some of these issues that we're seeing and that states are having to try to address through regulation. And there are several public health issues, I think, tied into this. The food safety element, which I will not talk about because I would talk about that way too much, and I've already gone over my 4 minutes, and I probably haven't been that entertaining in those 4 minutes. But we'll look at two big issues of dosing, or what's kind of the idea of overconsumption of THC that is a real challenge with these products because they function differently than the combustible product. The way the body metabolizes it, when you use a smokable product, it is quickly brought into your bloodstream and affects your brain within 10 minutes, is kind of the standard of when you have the onset of symptoms. But with edible products, it goes into your digestive system, it is metabolized by your liver, and the onset of the THC's effects can be up to 3 to 4 hours. So you have this challenge where it's, because of the body's metabolism, the effects take longer to set in. So people, all right, I had my brownie, I'm not feeling anything, it's been 10 minutes. Normally when I'm smoking this product, I'm feeling something by now. This must be a bad brownie, I'll eat another one. Oh, or worse yet, gummy bears. Oh, I'll have 3 more of these, or 4 more of these, THC and corn syrup, I'll have more of that. So when the THC actually kicks in, they have overconsumed the product. So you have the delayed onset, but wait, we can make this even more challenging because edible products can be crafted in a way that they're incredibly potent. And we're gonna look at some of the challenges that states have encountered with these kind of hyper-potent THC products, or products that are sold at a premium. People will pay too much money for too much THC. And also, with some of these products, it's hard to figure out how much you're dosing yourself with. Well, and we'll see this, if you're eating the Elvis cookie, and no one should ever eat this Elvis cookie, it's 1,000 milligrams of THC per cookie. That's insanity. How much of that cookie, how would you get a recommended dose of 10 milligrams when you're dealing with something like that? Even in a more reasonably sized administration, edibles create a challenge for serving size. And then, a lot of these are, baked goods, confectionaries, candies. How do you ensure that the THC, psychoactive component, is distributed uniformly through the product? And that's a challenge that they have in manufacturing these. So dosing is one big issue, but then another common sense issue is attractiveness to children. So gummy bears, lollipops, they have they have cannabis cotton candy, which I know is not targeting people in their 40s like myself. It's really things that are, really attractive to children because their non-cannabis forms are really marketed at children. So you have these products that are high sugar, look like traditional food products targeted at children, but have cannabis in them. So with legalization, you have increased challenge with child consumption. Accidental in many cases. So in Colorado, after the legalization, they compared hospital ER visits and poison control calls, pre-legalization versus post-legalization, and there was a significant increase in both of those. And most of the exposures were as a result of ingestion of edible products. So you have this issue of exposure to children. There's also unique health concerns for children with exposure to cannabis. And a lot of that has to do with brain development. So the idea that the brain isn't fully developed until we're in our mid-20s. And children exposed to this, it can affect their cognitive development. So there's unique challenges there. There's also the idea that this could be attractive not just because it is a sugary treat, but let's say I'm not a 3-year-old who mistaken this cookie as an appropriate cookie, but I am a 16-year-old trying to conceal my consumption of a cannabis product. It's easier to consume a cookie and not smell like marijuana smoke and hide that consumption. So there's a concern that it will lead to earlier initiation because it is a more concealable use of cannabis. So let's talk a little bit about dosing and a potency problem. This is the black bar, which is a product with 1,000 milligrams of THC. It's not legal in all states, and we'll talk about that. The Elvis that I mentioned earlier, which apparently Elvis had a thing for fried peanut butter and banana sandwiches. They tried to put that in cookie form. So you have these products out here that I mentioned that are these hyper-potent products that lead to the dosing challenges. So how do you deal with this? Because as edible products were in markets in states that were early adopters of legalization, whether medical or recreational, how do you prevent this overdosing, not in the sense that leading to death, but leading to a lot of the serious health problems you have with over-consuming THC? And states started to learn and look at, well, maybe we should restrict the THC content of the products we allow to be sold in our state. Maybe having the black bar or the Elvis bar available isn't a great idea because not only were there increased ER visits and poison control calls for kids, there were also increases for adults as well. So some states are adopting potency restrictions. And they'll look at defining what's a serving size. So what is the recommended dose if you are consuming this recreationally or as a medical product? And so some states like Massachusetts have said the standard serving size for one of these products is 5 milligrams of THC, and the most THC that you can have in a product is 100 milligrams. It's 1/10 of the Elvis cookie. So you have these products here. So you're going, all right, one way we can do it is limit the amount of THC in a product. Well, that idea of well, how do I determine what's the 5 milligram serving size? States are starting to require things like demarcation of serving sizes. So if you see the chocolate bar at the bottom, the serving size is scored out so you can break off one square to know that you have a 5 milligram serving or a 10 milligram serving. But there are some challenges. It's harder to score certain products, especially if you are doing things like allowing, some states allow like THC infused dried meats, anything under the sun that you can consume as a food, someone is trying to infuse that with THC or CBD. So states have taken different approaches. Massachusetts, I think, is more protective and says if you can't score or demarcate single servings in your product, you can only sell it in a single serving size. So a brownie or a cookie that may be more challenging to break into portions. It's only, if you can't do that, it's gotta be a single serve, single wrapped 5 milligram portion. Another thing that states are doing, they're looking at putting warning labels saying, hey folks, you take this product, don't be disappointed if you're not experiencing the psychoactive effects in 10 minutes. This could take 2 to 4 hours for the effects. So they're putting that on the product, requiring that on the product. And they're also requiring the manufacturers of these to have procedures in place to homogenize the cannabinoids in those products. And then the states are testing to make sure that there's indeed dispersal of the main components. Now, attractiveness to children. This is something that was put up by the Denver Police Department. It drives home the point. To a 2 or 3-year-old, 4-year-old, 5-year-old, to me, I can't tell the difference. So this is one of the challenges that states are dealing with. So they use some common sense approaches to addressing this issue of attractiveness to children. Now, in many states, these gummy bears aren't allowed anymore because states are starting to put product restrictions in place. And a lot of the regulation and language starts off very general. Say, okay, well, we're going to prohibit edibles that by shape, design, or flavor are likely to appeal to children. That captures a lot of the stuff that's out on the market, but some states get down into more detail. Say, all right, well, what specifically appeals to children? Well, we know, cartoon characters, foods in the shapes of animals, fruits. These are things that we're going to prohibit because that really targets children. And some states, specifically say, well, your gummy worms, your Sour Patch Kids, knockoffs, those are all the way of the dinosaur, but you can have geometric shapes. So, they're stepping in and giving some advice in terms of permissible shapes. But they also are taking steps, because early on in a lot of the programs, you had manufacturers really infringing on the trademarks of established food products. And I've got a picture of, you've got Oreo knockoffs, you've got Reese's Peanut Butter Cup knockoffs, and it's all with very clever wordplay, letting, kind of jokingly making the association between cannabis and their product. But states are putting laws in place saying you can't do that anymore. Not only are you violating, federal trademark law, you can't do that under state law because this is something, is a product that children aren't going to be sophisticated enough to make that distinction. So we want to remove that option. And then some states are saying, we're going to specifically identify foods that, regardless of your attempts to have this be less appealing to children, are just so intrinsically child targeting that we're not going to allow it at all. For example, cotton candy. The idea that in Washington, they're like, well, we won't have it be yellow or red or pink or blue. We'll just have this very boring white cotton candy in a bag, and we won't have any cartoon characters. And they're like, no, this is really a product that is inherently targeted to children, so we're not going to allow this to be sold in our state. Now, another area where states are trying to deal with this attractiveness to children, is packaging. So common sense, why don't we put, in every state that I've researched up to this point, has child-resistant packaging requirements. And in all the states are referring to the standards at the federal level so that it's harder for children to accidentally get into these products at home. The 2 containers at the top are actually off of a manufacturer's website that creates packaging for edible cannabis companies. Again, there's a general prohibition in how the foods are packaged so that they're not attractive to children and, don't follow the same marketing as, already established products. So you have Buddha Finger up here, Trichome Crunch, Keith Cat. These are no longer legal ways to market your edible cannabis products in most states. But also, warnings are placed on these so that, whether an adult or a child that can read can hopefully distinguish this as not a, traditional food item. Some states even have special symbols that they have placed on the required to be on all of the packaging for cannabis edibles. But these are just a couple of the issues that states are starting to deal with, because when these products first came out onto the market, they weren't doing these things. So you had the problems with hyperdosing of THC and child access, and states are slowly starting to test out these different approaches to deal with those two issues. But again, this is just kind of the tip of the iceberg. You know, if you were to look at issues of food safety, you come into challenges of, these aren't food. How do we regulate these? States are trying to figure out how to look at issues of food safety with a product that doesn't fall within their traditional food safety system. And, we talk about food labeling. Well, food labeling doesn't apply to these, so states are creating their own labeling standards in terms of nutrition content. People need to know how many carbs they're getting when they're getting their 10 milligrams of THC, but also more common sense things like, requiring food products to have allergen warnings on them so that individuals who are using these know that, what ingredients may trigger an allergic reaction or their specific allergic reaction. So there's a lot, I think, to learn, because this product does present a lot of unique challenges and, kind of fits between agencies. Often you'll have, in states, you'll have, for example, the Department of Revenue regulating the industry of cannabis, but then it's the Department of Health that's responsible for the food safety aspect. And so creating partnerships across agencies and figuring out how to deal with the unique nature of these products is, I think, an interesting public health challenge that Maryland may have in its near future, depending on how the bill goes before our legislature. And I talked for like 30 minutes. But that's it. I'm going to hand this over to the boss.
I do just want to point out that you said you wanted to go last, so that was not my choice. So we were going to serve brownies, but we served cupcakes at lunch so as not to confuse you. I do have a colleague who was teaching marijuana law at another school, and I suggested that on the first day of class she have a pan of brownies that said with and a pan of brownies that said without, and I meant nuts, of course. So people with allergies shouldn't take the nuts ones. Anyway, obviously I'm getting punchy because these are the things that I'm talking about now, and I really want to just express my gratitude for all of you staying in this room, but really being with us here today. The engagement that you guys offered to us was remarkable, and that's what makes a day like this survivable, but also really enjoyable. So on that note, if you have questions for any of these panelists, you can submit them to the Network for Public Health Law, and we will answer them. So it's kind of a trick to get some technical assistance requests rolling in. That's always our best source of what we should be tracking in the Network for Public Health Law. The questions really drive where we end up putting our work. So in addition to saying thank you to Tessa, Hans, Brooke, Blair, Gabby, Matt, all the folks who preceded me, Megan, who makes every day functional at the office. Carey, my right-hand man and the person who explains everything epidemiology to me, and all of the students in the room who took time out of their day to be here. I just do want to say farewell to our colleague Melissa Sager, who is sitting in the back of the room shaking her head for me not to do this, but today is Melissa's last day with the Network for Public Health Law. She is moving to Denver to help a couple of local health departments in that area learn how to better interact with their policymakers and to do so with a legal lens. And so we're really proud of Melissa and are going to miss her desperately here. So thanks for being here and join us in saying farewell to our colleague, Melissa. And don't forget those evaluations.